Morning. Welcome, first of all, to those who have braved an early, cold Saturday morning to be with us, and to the majority of people, I suspect, who are in their pajamas at home. Welcome also. You can get your coffee now and settle in. Yesterday, we basically went through the nuts and bolts of compliance regimes. Today we're going to do something a little different. We're going to carry it forward. And in this session, we're going to do three things. First of all, we're going to use a case study to basically highlight what we learned yesterday. And that case study, if you've looked at it, is basically a pastiche of every lawyer's collection of nightmares, and they all come together. With cases that are familiar to every Canadian lawyer, or environmental lawyer at least. Next, we're going to learn some lessons from the United States, and these are lessons not in how to select a candidate for president, but lessons in what they've done in the United States, including at the federal level. And that is not irrelevant to Canada, as you know. There were significant references yesterday to EPA experience, and one thing about the United States, they have a lot of money to throw at problems, sometimes wisely, I guess, and sometimes, as elsewhere, not so wisely. But we often look to the United States for new approaches to environmental law, going right back, of course, to NEPA. And finally, we're going to listen to a piece on intelligence-led environmental enforcement. Now, intelligence-led approaches have been used in criminal law for some time now, and Heather McCready is going to talk about how some of those approaches may be transferable to an environmental situation. So we'll begin, first of all, with the case study, Every Lawyer's Worst Nightmare, and it is with Jennifer Fairfax we begin, who is a partner with Osler, Hoskin, and Harcott in Toronto. Jennifer?
Yes, that's going to need to be lowered to a great extent. Hi. All right. All right. So, as Owen said, we're looking at a hypothetical case study today, and it was my role to bring together the hypothetical case study. And you know, I thought, can I use one case? Is there one big fact scenario out there, like Bloom Lake or Mount Poly or something that I could use as the example? But really, we don't have a lot of case law on those decisions. So what I ended up doing was crafting one, putting it together using various different cases, and coming up with something that is kind of a disaster scenario or a client's worst nightmare. And depending on your perspective, a lawyer's challenge. So I'm going to go through a little bit the hypothetical fact scenario in case you haven't seen it in the paper. There's 5 overall lessons learned in the paper. I'm not going to focus on all of them because we covered a lot yesterday. Yesterday we went through a lot of the inspections, investigations, know the difference and understand that, so I'm not going to cover that. I'm not going to touch on search warrants because that has been covered as well. But I'll be focusing in a bit on relationships with regulators. That actually should say regulators, but you should have a good relationship with regulations as well. And then also focus in on due diligence and a little bit on employee interviews as well in the context of our hypothetical fact scenario. So with a very recent case that came out, I guess, October 2015 in New Brunswick, the Strata bound decision. It's a mining company. It was faced with charges under the Fisheries Act and convicted for releasing a deleterious substance. And a quote from that decision I think is quite apt. Obviously, in today's environmental landscape, the polluter pays principle is prominent. We're seeing more and more of it in the civil realm in the courts and in the quasi-criminal judicial realm. So this quote I thought was quite apt to start off our discussion. Flagrant abuse of the environment resulting in harm or potential harm is not to be tolerated because the protection of the environment is essential to the health and well-being of all creatures and plants living on this planet. Polluters must pay for the cost of their illegal actions. So keeping that in mind, a couple caveats before we go into the hypothetical fact scenario, and I'm going to steal from Roz Cooper from yesterday. And that's basically, we're looking at lessons learned, best practices, but one size does not fit all. So your best practice is your best practice in the circumstances, but if the circumstances are changing, you're going to have to adapt to your best practice. So that's the hypothetical study that we'll present as a lens, but keep that in mind. But really what I think is key in my view, I'm a litigator. I like the courts, but I'm also an environmental practitioner. I have a hybrid practice, and what I think is key is working with regulators. And why is that? As a company working with them, collaborating with them. Obviously, you have a good business. You want a good business reputation in today's world. But and again, I steal from Roz again. But I have very virtuous clients who want to abide by their environmental obligations, who don't want to pollute. And so this is the reality we're dealing with. And quite frankly, the risks are just too high to ignore environmental violations. So, okay, moving to the fact scenario. So what we have is a gold mine. It's in financial distress. I specifically have not put it in the insolvency context, but if you want to put it there in your own minds, you can. But it's not there in the financial in the hypothetical study yet. The mine site is in Remoteville, Canada, and I chose that because I didn't want to put it in any particular province. So take what you want from the study on that. It's in the care and management state, so it's not operating, and it's got heavily reduced staff. The tailings ponds on the site, they're continuing to accumulate water. Obviously, even though you're not operating as a mine, your tailings ponds will continue to accumulate water because of precipitation. And the legal height for the ponds, which all sites will have, is close to exceedance. So there's a risk of an overflow, an uncontrolled overflow to the environment with the approaching spring thaw. And the regulators, everybody's aware of this situation. They're conducting inspections, both provincially and federally. But the problem is communications with regulators have broken down because the company's in distress, there's reduced staff, communication's not doing well. So what happens is the regulators are not getting the response they need, and they order the mine to lower the water levels to a safe level. But to lower the water levels, the company has to, in their view, treat and release waters to the environment. And so you can actually do this under the metal mining effluent regulations. You can release mining effluent if it meets certain requirements for toxicity and if you've met the requirements under the regulations. But the problem is, in this case, they release the waters, and they find out after the release that the waters are toxic to fish. They failed the toxicity tests that are required under the MERS. The company can't fix the situation. They've tried to adjust the treatment system. It's not working, but they continue to release waters. There's a sudden bad storm weather, and there's an inadvertent spill of 100,000 cubic meters of water. It's not noticed by staff for many hours, but when it is actually reported. And before the spill and after the spill, some of the EMS, environmental management system protocols, aren't exactly followed. Inspectors visit, certain documents are voluntarily provided. So now, at some point, the inspection turns to an investigation. And so the inspector puts on his hat or her hat as an investigator and conducts employee interviews with legal counsel present for the corporation on company time, company's premises, and more documents are provided. Now, I I understand, obviously, in Ontario, we've got the two separate divisions with the inspector and then the investigators at the IEB. But in the federal context, that's not the case. I've dealt with Environment Canada, where in the morning the inspector is wearing the hat of inspector. 1 hour later, the same person is wearing the hat of investigator. They're also acting as interim manager of all at the same time. So you have the same person conducting the investigation and actually doing the search warrant, and the next day they're inspector. So you're dealing with that kind of situation. So despite voluntary cooperation, the investigator arrives unannounced and does conduct a search warrant and takes files, those in plain view and also some potentially privileged ones. So prosecution is commenced, and the employee interviews are used as admissions against the company without calling the employees to testify. And so all while this is happening, all while the investigation's ongoing and the prosecution commences, obviously inspections are continuing because the inspectors need the company to maintain compliance with ongoing compliance with environmental laws. So again, these are the 5 lessons learned that you see in my paper. And I guess the first one really, and I think it's, again, a key one from my perspective, is that relationships with regulators, and that should say regulators, must not be allowed to break down. And I do think it is a red flag when you see that happening, and I've seen it time and time again. And I've had inspectors say it to me when I've become involved in a file and I'm trying to bring a site back into compliance and getting everybody working together. The regulator, the inspector, has said, look, I've lost confidence. I don't trust your company's people anymore. I don't feel like it's transparent. I'm not getting the information I need. And that's when you see the shift happen, I think, from voluntary compliance or abatement measures to mandatory compliance, and the orders start happening. And once you're there, and the inspectors have said this to me, it's an uphill battle to get you back down to the voluntary compliance world. So what do you do to help prevent that? As a lawyer advising your clients or as a company, a couple things you can do is assign a reliable point of contact. So there's one person within your corporation with whom you have a great deal of trust, who establishes that point of contact with the regulator, is the recipient of requests, is the person who provides the information, makes sure the information being provided is consistent and accurate, and responds promptly to inquiries. And then other things you can do is actually develop a proactive relationship with the inspector. Provide information proactively. If you're doing something at your company that's improving your environmental management system or is improving your water management plan as a mine, tell them about it. Obviously, reporting is a key one, but when you're in the situation of a company in financial distress, whether it's insolvency or otherwise, and operations have to cease, whether it's temporary or permanent or otherwise, be proactive. Reach out to the inspectors, the regulators, and tell them about it. We've done that in files in the insolvency context where the client's about to file, and instead of just letting them file and everybody finding out about it through notice, beforehand, give the regulator a heads up. Look, we've got to do this. We'd like a meeting. We'd like to discuss this with you. And we'd like to hear your concerns and have that meeting. So, and we've seen that work. I've seen it in cases where that proactive wasn't taken and the knee-jerk reaction from the regulator happened. A notice of intent to issue a direction under the Fisheries Act was hit the day of the filing. Once they knew about it, they sent out the direction. The day of the filing in the CCAA context, an order was issued right away. So because the regulator is worried, this site's in trouble, it's going to be abandoned, environmental obligations are not going to be met. And so you can have that meeting and be proactive and assure the regulator that that's not going to happen during the process that's underway. So bottom line is work with your regulators, establish that positive relationship. The regulator doesn't have to be the enemy and shouldn't be seen as such. Okay, so due diligence. You'll probably laugh, but people are probably very sick of lawyers saying paper, 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 paper what you're doing, paper what you're doing. But I think it's absolutely crucial that clients do create a paper trail of their due diligence. And yesterday, people went through the nuts and bolts of what due diligence is. And so I'm not going to go through the test by any stretch of the means, but I think getting a sense of what it means to a court is important when you're looking at this hypothetical fact scenario. So what is all reasonable care? So due diligence, one aspect of it is all reasonable care by establishing and implementing a system to prevent an offense. So what is all reasonable care? Courts have often defined it by what it's not, but sometimes haven't quite defined what it is. So what it's not perfection. It's not superhuman efforts. It's not all reasonable, all possible or imaginable steps. But it is a high standard of prompt action that a company needs to meet, and awareness and decisiveness. So courts have looked at various factors. People mentioned the Commander Business Furniture case yesterday. I've bolded a couple factors that are relevant to our fact scenario in particular. One being alternative solutions, whether they're available to the company to help them prevent an offense, industry standards, preventative systems, and economic considerations. So in our fact scenario, thinking back to it, have they established all reasonable care? Did they implement the EMS that they needed to? That one's a little bit more obvious, no. Were there alternative solutions available? Economic considerations. How relevant is it that this company is in financial distress right now? So in this case, all reasonable care. So the problem in our fact scenario is that it's foreseeable that during a non-operating state, you're going to have environmental incidents. It's foreseeable, obviously. And that it's foreseeable that you're going to have to meet your environmental obligations when you're not operating. That doesn't really matter. So should the company have reduced its staff and resources to the extent that it did? Yes, you're in financial distress, but what do you do about that? So in the Syncrude decision, it's just an example that courts in Canada do look at the reduction of staff and resources and consider that, at the time of the incident and prior, and consider that in analyzing whether due diligence has been met in the circumstances. And in Syncrude, the company was convicted for failing to deter birds from landing in its tailings pond. It was fined $3 million, and the court did find that they did not meet the due diligence test, in part because resources, staff, and deterrence were reduced prior to the incident. So EMS, you heard a lot about this, I think, yesterday, that EMS is a key element in all reasonable care. And obviously EMS, can't just be in place. It actually has to be followed, and it has to be updated and reviewed and not sit on a dust collecting shelf. So just because you have one doesn't mean you're going to guarantee compliance. And in fact, having one and doing nothing to meet it is probably worse, because then the court's going to say, you had this in place and you didn't actually follow it. So there's a couple instances, actually there's probably a ton of instances where this has been the case, and companies have been convicted for either not having proper EMS in place or not following it. And I've just given you two examples here, but I'm not going to belabor that. And in our particular fact scenario, it's pretty obvious that they didn't follow their EMS. But what's more interesting in our fact scenario is the alternative solutions sort of prong of the due diligence test. So what really could our hypothetical mining company have done in the circumstances? Because they don't have funds. They don't have staff because they don't have funds. They are sitting in a situation where the water levels are rising just because of precipitation. They can't do much about that. And to belabor the analogy, they're working upstream against this ever-increasing water levels and the approaching spring. So what reasonable, feasible alternatives are available to them in those circumstances? And that reasonable feasible is an important concept when you're looking at what alternatives should the company have put into place. And courts will look at what was reasonable and feasible in the circumstances when looking at the reasonableness of care. And this is just a quote from Syncrude that highlights that reasonableness of care is often best measured by comparing what was done against what could have been done. But when you're looking at what could have been done, you have to look at what's reasonable in the circumstances, and that includes economic considerations. So now, economic considerations, the fact that this company was in financial distress, how much does that matter to courts, to prosecutors? It's a little bit difficult to say because you still have to meet your environmental obligations. You have to try to meet your environmental obligations. And some courts will consider it and some haven't considered it, but it's a reality. And I think the Commander business furniture case is helpful in looking at this factor in particular. And what that case helps illuminate is that, yes, obviously cost alone can't be determinative of due diligence. And on the one hand, you've got the economics of these various possible alternative solutions need to be taken into consideration. It must be weighed along with all the other factors in assessing whether due diligence has been met. But on the other hand, and this is a nice quote, even in the bleakest of financial times, the environment must not be a sacrificial lamb on the altar of corporate survival. So obviously, it can't be determinative. So courts do what they typically do, which is a balancing exercise when faced with these things, and they look at a pragmatic approach. Because if you just ignore the economic realities that this company is facing, then there's no air of reality to the exercise of assessing due diligence. So they balance, the need to protect the environment with the cost of the measures. So obviously, if you're going to have there's a hugely, highly foreseeable risk of a really bad thing happening to the environment, then the court's going to expect you to spend whatever you can spend to prevent that from happening. But if you have something that maybe there's 1 in 1,000 chance of a rainstorm happening, 1 in 1,000 years that a rainstorm of this magnitude would occur that would cause you to have an overflow, and that's what you're told by your consultant, you probably don't need to spend the tons and millions of dollars that consultant says you need to spend when you're in financial distress. So you have to factor in the risks, the foreseeability of the damage or the potential damage. So our company was trying to abide by its obligations. It needed to lower the water levels. It knew that. It kept everybody on the up and up. It told the regulators what it was doing, and it tried to treat and release, but it wasn't working. So, and is this company in the situation where it's faced with a greater evil? If it doesn't treat and release in a controlled manner the waters, then they could have an uncontrolled release to the environment that could be worse, that could cause the dam to breach and more waters to be released. So what do? And what is their alternative in the circumstances? With limited funds, can they rent a water treatment system? How much time would it take to get that in place? Where can they get it? Do they have parts? Is there time before the spring thaw? All these factors need to be taken into consideration when assessing due diligence. So then we come to strata bound, which was one of the key cases building into the fact scenario, just because it was recent and it's on point with mining companies and water management issues that we're seeing a lot of lately. In particular, the Mount Poly breach, I think in 2014. So this company was actually in financial difficulties. It was facing dissolution. Its treatment system for the mine effluent wasn't working. It was having constant consecutive failures and wasn't able to fix it, but continued to release the waters. And some extreme weather did occur. There was significant rainfall, and so the water levels in the mines was at a bad critical stage. And they notified Environment Canada of that. And so they were facing this very situation. They're under pressure to discharge in order to increase their capacity of the pond so that they don't have this overflow. Environment Canada actually attended a planned release of waters to the environment to avoid this critical possible overflow. And inspected, monitored the discharge, took samples of it, and found that the discharge was toxic to fish. And the company, through all this, ended up being convicted. Now, the sentence was about $75,000, but this was actually pre-minimum fines before the Environmental Enforcement Act was passed, increasing the fines under the Fisheries Act to its minimums. So what were the lessons from Stratabound? Well, the court convicted the company despite its efforts, despite it keeping the Environment Canada up to speed at all stages, and despite its financial situation. So the court said that unexpected or extreme weather won't excuse a lack of due diligence. The vagaries of nature do not excuse the need to protect the environment. A lack of preparedness and inexperience is not an excuse. So yes, company, you were trying really, really hard to do what you should do, but you didn't know how to do it, and you should have gotten help. They were in over their heads, according to the court. And the court stressed, and you'll see this in cases time and time again, especially under the Fisheries Act, but there's no proof of actual harm to the environment is needed for a conviction. It's just the potential of harm that's needed. Now, in sentencing, the court did say, yes, we always take financial distress or financial economic considerations into assessing the proper sentence in the circumstances, but still felt that a fine was needed because of general deterrence to tell other minds, look, you've got to be careful here, and use it as an example. So I'm not going to go into a lot of detail on Mount Poly because I don't really know how much time I have. Okay, so you'll see it in my paper, pages 11 to 14. Mount Poly obviously is a notorious example, I suppose, in Canada recently of a situation, emergency environmental situation. But what really has come from it are some recommendations, which might affect the industry standard that's applied in the due diligence test for mine companies. We'll have to see. But industry standard is one of the factors that are taken into consideration by courts. And the Mount Poly recommendations obviously focus in on tailings ponds, on tailings storage facilities, otherwise known as tailings ponds, and have some specific recommendations for water management. And just yesterday, my colleague, Jack Coop, who made a presentation yesterday, forwarded me an email of a mining company who has been convicted as of yesterday, I think, of water management violations under the Fisheries Act. I'll have to, it's in my phone, but I'll have to get the name of it later. If anybody wants it, let me know. But they were convicted and sentenced to $175,000, again, for these water management issues. So it's obviously an ongoing concern, and particularly in the environment, I think, in Canada, with a lot of mining companies that are having financial issues with the commodity prices being down. So the next lesson learned after due diligence, I suppose, would be the inspections investigations divide. Again, I'm not going to go into that. Obviously, our hypothetical fact scenario, the company didn't treat inspections and investigations really any differently, and query whether they should have. Again, it depends on the circumstances, whether you cooperate in an investigation or not. But that was the situation they were faced with. In the paper, I do have a table that I think Jack and I carry over this old PowerPoint table from presentation to presentation, but I put it in my paper, and you can see it here, but it just gives you kind of a primer on investigations, inspections, and the difference between them. But I want to focus in a little bit more on employee interviews as one of the lessons learned. Again, in our fact scenario, the company allowed employee interviews on company time and the company premises, with the lawyer for the company being present and scheduling the interviews, etc. And really, that is taken right from the Syncrude decision, which everybody mentioned yesterday in the context of employee interviews. And you know, really, it's everybody has a different practice in terms of whether employee interviews in the context of an investigation should be permitted or not, or whether to do them or how to control them. But you need to know the end game or the potential end game so you can at least make an informed decision in the circumstances. And Syncrude tells you one of the worst case scenarios of that end game, which is if you allow the employee interviews on company time with company counsel present saying that they're representing the employees as well, you could, and the employees, sign the statements. The employees' statements could be used against the corporation at trial in a prosecution without the Crown having to call the employee to testify. So know your end game before you start dealing with these employee interviews. And it makes a lot of sense, I suppose, under environmental legislation. Companies, there's statutory provisions particularly allow companies to be convicted of offenses just because their employee did it, right? So it's permitted under statute, and so you need to understand what could happen here. Search warrants, again, in our particular fact scenario, search warrant was carried out. It was carried out even though the company was voluntarily cooperating and providing documents and letting employees be interviewed, and that can happen. And I've had that happen myself to companies. And I guess Jack and Jack Coop and Ross Cooper and Paul McCullough yesterday went through a lot of this, so I'm not going to belabor it. But one thing that I actually did experience, and I think it's interesting for corporations undergoing the experience to know, is that there is generally a time frame in which these warrants can be executed between 6 a.m. and 9 p.m. And there's some courts have given a little bit of leeway to that in certain circumstances. But I have had investigators show up with the RCMP and insist they can stay there as long as they want to midnight and beyond. No. That's not reasonable in the circumstances, and the company doesn't know that. They don't know what to do. And sometimes these companies are in remote areas. They don't have lawyers on site, and you need to be ready as a lawyer to understand the parameters in which a search warrant can be conducted. Get on the phone with the investigator and tell them your position, and if they insist they can still remain for as long as they need to, or otherwise, then paper it. And again, paper, but send them a letter, outline your objections, and then if it goes to prosecution, you've got a record of some of the objections to the way that the search was conducted. So overall remarks, in terms of concluding remarks, just some takeaways. I'd be interested, though, to hear, because obviously the fact scenario has a lot of elements to it where things go badly for the company. So if others have thoughts or questions or that they want to discuss, the point of it was to foster discussion. Okay, thanks.
Thank you very much. You can stay right there. We have time for a few questions, I think. Yes.
It was an excellent presentation. Thanks very much. I find that when there's a situation like that, you have a spill to the natural environment, but that's just the beginning. It's an indication, as you said, that companies in financial distress, they may not be able to manage the situation. Mm-hmm. And when the Ministry of Environment gets on that situation, number one, right under Part 10, I don't know if this is working anymore, but under Part 10 of the Environmental Protection Act, it's clear that you definitely have to restore the natural environment. So whatever contaminant is spilled, that company is responsible, regardless of due diligence, whatever, and so they have to restore the natural environment for contaminants that have been spilled. Mm-hmm. And what we're focusing on when we get to the prosecutions you're talking about is what happened before that incident. Mm-hmm. Going forward, though, if the ponds are still, way above, et cetera, then you're dealing with potentially an order, probably for sure, to basically take measures so it doesn't happen again. And the key thing I find that the government may do, at least at the provincial level, is they may go in and do the work themselves.
Right.
And that's where the financial district, look, if there's a company that can't manage it, they can't sit there going, look, we don't have the money to invest in it. That's where the province, and I mean, I'm sure the province, like, we don't have any money to do that, but we do have an emergency response fund. And we do go in, as you know, in certain situations and cause work to be done. You know, some very long legacy things like Deloro. But the reason why I think that's important is because the government sometimes does go in. The difficulties, you know, from the insolvency situation is right when we do, we lose all sort of the order now being seen, you know, we have no...
Then you're just stuck in the
That's
queue.
right, we're stuck. But that's not the point. The government does have the ability, if it needs to make sure it doesn't happen again. And they can cause work to be done. And right when the government issues that order, actually the company can't do anything. It says right in the legislation that right when you cause work to be done, you issue that notice, the company can't do the work. They have to step back. They're going to face an order to pay costs. And so the reason I just said that through is because by the time you get to court a year and a half later, all of that may have taken place. And the only focus on the court is what happened for that, you know, going back to your thing, somehow they allowed that discharge to take place. Did they not test for acute lethality? We don't know. I mean, in your test situation. They allowed this thing to go to the water. They should have, right, under especially the MESA regulations or whatever. They should have tested for acute lethality. And right there, I would be saying, okay, so you allowed it to go through, but you didn't test before it went to the acute lethality. That's a problem. But that's what I find about prosecutions is they focus on those 2 days or 1 day, but the story always goes on way beyond that. And at the prosecution, of course, it may come out, but it's irrelevant at that point to what happened right to the initial spill. And so that's why I go back just to the story of the prosecution is just a freeze frame. I find that all of a sudden there's a bunch of things that go on afterwards, including orders and including sometimes where government has to step in and take over the cleanup.
Yeah. And what's difficult about the acute lethality test is the test can be run, but sometimes for one of them in particular, it takes 3 days for the results to come back. So then sometimes the water's out. It's gone through the system, it's out. And then you find out 3 days later, oops, we failed the toxicity test. So it's a problem. Yeah.
Hi. My question is, you mentioned that inexperience is not an excuse. You should hire an expert. So say you do exactly that and they're not able to. It's still failing the treatment. What say that same situation, what kind of happens then?
That's a good question. I mean, it's a factor that would come into play. Would that have changed the court's ultimate decision in finding that the company was over its head, which I think in Stratabound was a key factor for the court? If there had have been an external consultant who had been hired and also couldn't figure it out, and it was just these ridiculous, crazy circumstances, maybe that would have changed the outcome.
Can I have just a very short question, or if not, I can. I'm wondering, you can paper all concerns. Is it a reasonable ground for, like, if your concern is I need to take action now and providing the information you need for the investigation would require too much time, I don't have the resources, is that a valid concern? Like if you're working on taking action to resolve the situation?
Yeah, it is. I think it is. If you're in the situation where you're working with the regulator and they tell you got to do this by a certain date and there just isn't time to implement it by that particular date, you can't get the parts. Once you get the parts, like say you can't get the parts for 4 weeks. Once you get the parts, it's another 4 weeks to implement. All of that, I think, does need to be taken into consideration. But how did you get to the stage where at the emergency where, there isn't enough time left? Maybe before that you should have been doing stuff. So it all becomes part of the big picture. It's hard to really say, but I do think it's factors that I have had regulators take those types of things into consideration.
Can I ask just one last question? Because I think for the average person in the street, this might be an issue. You talked about economic consideration / financial distress.
Yeah.
I think everyone would understand that it makes sense that there should be some balancing for society as a whole in terms of how industrial activities should be conducted as opposed to protecting the environment. I think everyone would understand that at sentencing, you would take into account the particularities of a company when you assign a fine, including financial distress.
Yes.
I think the one that's most counterintuitive, though, and I guess it comes up in Commander Furniture, is the proposition that you take into account the particularities of the company when you actually look at due diligence. That due diligence is not something that's set by society as a standard, but it would actually vary with the financial ability of the company. Is there any pushback against that idea? Because I think a lot of people say, well, if they can't meet the societal norms of that trade-off, then they shouldn't be doing business.
Well, yeah, the cost of doing business factor. Yeah, well, I don't think it's quite that in Commander Furniture or in the other cases that that like the financial distress always would lower the standard that's applied to the company in the circumstances. It's just part of the entire matrix that a court will look at, and it's something. The economics of the company is not something that really should just be ignored in the circumstances. And I think that's because, and again, it always depends on the circumstances. What is the offense we're dealing with? Is it, the offense of not filing reports on time? Is it the offense of releasing, 100, a little bit to the environment? Is there's a huge quantum? What's the level of harm? All of these things come into play. So a court's if the foreseeability of the harm is high, if the severity of the harm was high, and the company knew that and didn't take the measures that they should have taken, a court's going to find them guilty even if they're in economic distress.
Sure.
And they do look at what society is going to expect in those circumstances.
Okay. Thank you very much.
Okay.
I think it's, thank you, Jennifer. We're going to move on now, and we're going to hear from our American cousins, or at least cousin. And I'd ask you to welcome Jonathan Leo, who is with a practicing attorney in California, which is where most of us would prefer to be right now. So welcome, Jonathan.
Thank you, Owen. I'd also like to start by thanking the Canada Institute for Resources Law and Alan Ingleson in particular for giving me the opportunity to be here today. It's an honor and a pleasure, both. My purpose here really is to give you some perspective on American environmental law and really in the context of what I've been hearing, what I heard yesterday, what I heard again this morning in Jennifer's presentation, some sort of the way that much of what you described in the Canadian environmental regulatory and statutory regime is or would be accomplished or handled in the U.S. A couple of things immediately jump out at me in terms of what Jennifer said that I'd like to point out. And the first of them is that it's impossible to overstress the importance of a regulated industry developing and maintaining good relationships with its regulators. In many cases, one regulated business in the U.S. will have ongoing relationships with a number of regulatory agencies, both municipal, sometimes county as well, state and federal, depending upon what kinds of materials it handles, treats, disposes of. And it is truly critical to keep costs down and to maintain good relationships, which will only pay dividends, positive dividends in the future, for company staff at the facilities that are regulated, as well as in-house counsel and outside counsel, to develop a good working relationship with regulators. I don't mean taking them out to lunch or having a beer with them necessarily. In some cases, it's the last thing you'd want to do. Maintain a professional distance, professional relationship at all times. But, and here's the key, you need to be perceived as having integrity by regulators. And when you are, like many of us, a lawyer, you sometimes have an extra burden that you discover you come into play with, which is at best mistrust, at worst contempt, because you're perceived to be a mouthpiece for the business that you represent. You're expected to bend the truth on a routine basis as far as it can be bent in order to protect and further your client's interests. And so, on occasion, you will find that regulators are transparently taking everything you say with a grain of salt because you're the attorney. I found that occasionally telling some good attorney jokes to regulators helps to break the ice. But the point is that particularly, again, when you're counsel, whether in-house counsel or outside counsel, you really ought to, in the U.S. at least, and in certain jurisdictions more than others, be conscious of the perception of the lawyer as someone who is there to spin the facts. The more that you can be straight with regulators on behalf of your client in the way that you present facts and the way that you work with those facts and the way that you show that your client and you are there to fix problems, avoid problems above all, but fix the problems that are obvious. Don't shy away from being honest about what has become public record and may be adverse to your client. If it's known, if it's public, the regulators know it, don't pretend it's a secret. Deal with it. It's open, it's out front, and you're going to be able to do a lot better work. What I want to cover quickly is some of the things I've been reacting to in the last day, yesterday. This is not going to be organized other than in terms of some of the things that were said by different speakers yesterday, which I want to provide some American perspective on. And I'll start with three examples that, from cases that I've worked on. Two are criminal prosecutions. One, actually there are two very short ones, in the context of the California Environmental Quality Act, known as CEQA, which is the California state's equivalent of the National Environmental Policy Act, NEPA. NEPA, which I've heard mentioned a couple times, is the piano of the instruments available in environmental laws in the United States. It's the mother of all environmental laws. It covers all territory. Whenever any project requires any governmental agency discretionary approval in order for it to be implemented, it requires environmental assessment, environmental review. The criminal ones first. All clients are not virtuous. It is true, in my experience, that no one wants to pollute, but the incentives to pollute when you are financially strapped, when a business is financially strapped, when it looks at the costs of a water treatment system, when it looks at all of the ancillary costs of employing experts and consultants as well as your own staff. If you're not doing well, then you're looking for ways to cut corners. And to this day, 40 years later, after the environmental law started to get enforced aggressively, and certainly in California and other jurisdictions in the U.S., this is still a response of a lot of businesses. Get rid of the waste without paying the right fare. So, in Los Angeles, in the early 1980s, there was a liquid hazardous waste storage and transfer facility situated in East LA, a very heavily Latino area, lower middle class and poor Latinos. It was a triangular yard facility that was at the apex of the triangle, two freeway systems crossed at the top of the property. That's an important fact you should learn in a moment. My environmental crimes prosecutorial unit in the Los Angeles City Attorney's Office routinely helped the Bureau of Sanitation issue permits to businesses that needed to discharge treated waste to the city's sewer system because of the industrial processes they engaged in. You can't discharge waste to the sewer without a permit, and the waste you discharge must be within, from a pH perspective, between 5.5 and 11 on the pH scale. Not too acidic, not too base. There are constituent limits, there are banned constituents, etc. So there's a very elaborate regulatory system. one of the inspectors for the city of LA, who we routinely dealt with when there were issues, he would bring violations to us. We would evaluate them. We would decide what we wanted to do with them. Came to us to tell us that he was going to be retiring from a career of over 30 years in government. This will also give you a perspective on some whistleblower ideas as well and where they can come from. And he said, and he's a guy we dealt with for maybe a year and a half or 2 years, very nice, pleasant guy, knew the system backwards and forwards. And he said he had a confession to make to us. He said he had just been diagnosed with terminal lung cancer and perhaps had at most a year to live. And it had given him perspective, he said, on his life and his work. And he needed to talk to us about some things that had been bothering him about what he had not done while he was on the job. And one of the things he told us about was this company called Capri Pumping in East LA, where he said he had allowed himself to be taken out to lunch by the owner of the company on a regular basis. Essentially, he had looked the other way on a number of occasions and not filed notices of violation against the company. And because of what he recognized was the magnitude of his own neglect of his job, you could use stronger words, of course, he wanted to come clean in more ways than one. So he gave us a lot of information about what Capri Pumping was doing and how they were doing it. He asked for immunity from any prosecution, personal immunity, if we were to file charges against the company. We had not yet brought any criminal charges against anybody. This was very early in the game for us. But when we went to the company, we got a civil inspection warrant and discovered that there were 8,000-gallon Baker tanks on the property holding hydrochloric acid, hydrofluoric acid, different liquid cyanide wastes. This is a company that picked up in vacuum trucks highly toxic, highly acidic aqueous wastes from the aerospace industry facilities in the San Fernando Valley in Los Angeles, from major electroplating facilities. So there were chromic metal wastes. And the Baker tanks, 8,000-gallon Baker tanks, had corroded bottoms, rusting sides, sitting on bare ground. There were no berms. There was no secondary containment. They had a private lab on their site that they operated. The laboratory director, when he was interviewed, had a very strong smell of alcohol in his breath. One thing led to another. We discovered that there was a priest in a Catholic church almost across the street from this facility who talked to us about some of the health concerns that the residents were expressing to him. And it turned out that after a series of other inspections, children in families that abutted this property, because they're so poor, grow their own vegetables for their own food, their own consumption. And the children had elevated blood lead levels as a result of the uptake of these metal wastes that would go into the ground under the facility, down across gradient, be sucked up by the roots of these vegetables that were being planted in the backyards. So the vegetables they were eating had lead levels in them as well. It was an example of how bad an operation can be, how long it can exist despite regulatory oversight. Obviously, the regulatory oversight here was wrong. But it's an example of a number of things, where you can get your information from, and also the importance of knowing your neighbors. We were able to we used civil injunctive relief to close this place down, but we did it and we could not have done it as successfully without the help of the neighbors. The residents who, with the help of the Catholic priest, were able to work with us, help us develop evidence, and show in the early days of environmental prosecution a very, very, we were all ignorant in those days. Nobody knew what the rules were. We were making it up as we went along. Judges didn't know about this law. We had to educate the judiciary in the city of Los Angeles and the county of LA. The defense bar didn't know how to defend industrial clients. So we were all learning as we went along. And with the help of neighbors who have obviously a vested interest in their own health and their own community, we were able to get very good results. Another example, and this is a criminal warrant situation, a major internationally traded metals company in Los Angeles, which had a block square facility, industrial metals processing facility. They were traded on, I believe, the New York Stock Exchange. Was so large that, and by virtue of the fact that its property was situated directly on the border separating Los Angeles County from Los Angeles City, so they had to have, and they had multiple discharge points into the city and the county sewer systems, so they had to have permits from both the county and the city, depending upon where their discharge points were. We got a phone call, this little fledgling prosecutorial unit in the LA City Attorney's Office. We got a phone call one day from a man who said, "I've seen some of the news about your prosecutions, and I have some information I think you'd like to know about. But I have to meet you in a very public place. It's got to be in the middle of the day. There've got to be a lot of people around, and I'll have some equipment and some diagrams that I can show you. No more information." He set a time and a place. You know, we're greenhorn young lawyers and haven't done any other legal work before, and we're thinking this is a setup. We're going to get blown away. I mean, we're in L.A. We were thinking Hollywood, and so we got LAPD undercover, 3 or 4 LAPD undercover officers to act as backup for us. We had a rough physical description of this guy that he'd given us, so we'd recognize who he was. We met him in a restaurant in a mall just east of downtown Los Angeles at 12 noon, lunch hour, so lots of people around. And we see this guy walking toward the restaurant with a very large duffel bag. Now, I mean, you think of this now in an age of international terrorism, and the stakes obviously get even higher, but these were the young and innocent days in the early 1980s. So he was intercepted. He was patted down. He was asked if he was the guy from Plessy Precision Metals. He said yes. They opened up the duffel bag. They confirmed that there were pipes, joints, plumbing, some electrical wires. That was all that was in the bag. He proceeds to tell us, as we have lunch, that the reason he came forward is because he has now finished and is on the wrong end of a wages and hours dispute with his employer, and feels that he's been stiffed, has been treated unfairly, has made a complaint within the company. It was denied. He feels like he's unappreciated, being treated unfairly, and he's basically blowing the whistle on his employer. A very important lesson in terms of labor relations: keep your employees happy, and to the extent that you're outside environmental counsel working with in-house counsel in a corporation, get to know your human resources people. Get to know the in-house counsel who deal with labor and employment law, and quite seriously, make them aware that they need to help you identify employees who they feel are disgruntled, may have a reason to retaliate against another employee they may be working with, or against the company itself. It can't hurt to have as many feelers out as possible. Long and short of it is, this guy says to us, about three-quarters of a year ago, he was instructed by the vice president for environmental management at the company to set up a rigged system, both electrical and plumbing. He was the chief plumber and electrician for this facility. Set up a rigged system whereby when the county inspectors arrived to check the clarifier and discharge point into the county's sewer system, a switch could be flicked on a wall, fresh water flushed through the county clarifier and into the county system, and untreated waste routed through the city system. And when the city inspectors came, a different switch was flicked and the reverse process occurred. Fresh water was flushed through the city clarifier, untreated waste or marginally treated waste was flushed into the counties. He had a memo days before email instructing him to set this up. The writing was on the wall. So first thing we did was to work with the Sanitation Bureau of the County of Los Angeles, as well as our own city inspectors from our own sanitation department. We got a combined warrant for the county and the city systems, and monitored discharges for about 2.5 to 3 weeks. Found out when these discharges were most likely to occur, and went in with a warrant at the appropriate time. And as we reported to the press when they asked us how we did, they said we caught them with their hoses out and their pants down. It was one of the easiest cases we had because the evidence was there. We put one of these, the vice president for environmental management, actually in jail for 30 days. It was the first time a corporate official had ever been jailed in connection with a hazardous waste violation. It shows about the importance of warrants. Talking about the timing of a warrant, there was another case in which we found, after going after the wrong company for violating sewer discharge ordinance of hazardous waste violations, that they in fact did not use the chemicals which were showing up in their treatment system. So we started putting up, with the sanitation department's help again, we put samplers upstream in the sewer system and ultimately found the entity that we thought was responsible for these highly acidic metal discharges. The acid levels, I think, were from 0.8 to 1.3, so way, way below the 5.5 limit. And the danger with this is that reactive chemicals in the sewer system can cause explosions, can cause gas releases, can kill sewer workers, can come up through vents in buildings. There's a serious public health hazard potentially here. We discovered that between 2 and 4 a.m., this company was, and they were bumper platers for Volkswagen and a couple other companies near the LA Harbor. And between 2 and 4 a.m., they discharged almost untreated, highly acidic liquid waste directly into the sewer. We came in, authorized by the magistrate who issued the warrant, at 2 a.m. with LAPD, LA Fire, 2 sanitation department workers, and took samples and got the results that we expected to get. The president of the company harangued me for about 25 minutes about how his uncles and his parents had left Nazi Germany to escape the Gestapo, and lo and behold, he was finding the Gestapo present here in Los Angeles, destroying his business. Now, as a Jew, this was harder for me to take, perhaps, than it might have been for others. I discovered that the sort of the steely mode of just sit there and keep your mouth shut approach to this that I was instinctively taking served me very well. But it was also an example that I carried with me as an attorney in private practice, because I realized that there are a lot of people who find the idea of environmental law being used as a criminal enforcement tool against businesses is beyond belief, and something to be ridiculed and eliminated as quickly as possible. And I appreciate your reference to the American elections, because we're hearing it again. It's an idea that doesn't ever go away. But it's important to understand the corporate culture of your clients. There is an incomparably wide range of ways that businesses interact with and accept or don't accept regulation. There's a wonderful article in a new issue of the Natural Resources and Environment magazine published by the American Bar Association devoted to environmental enforcement. And the title of the article is, "An Environmental Crisis is a Terrible Thing to Waste." And the idea of the article is that as corporate counsel, you should look at, if it ever happens to your client, a genuine environmental crisis, and a crisis along the lines that Jennifer was describing, perhaps not with a company that's on the verge of insolvency, but one that has a catastrophic failure of its environmental management processes and results in a real, not theoretical, not potential, a real harm to the environment or public health. That's the time when you need to really get the attention of the officers, of the people who you deal with in the corporation, and clearly something went wrong in a big way. Whatever kind of environmental management system or environmental audit system they may have had in place failed. You need to do, obviously, the failure analysis, but when you have finished that immediate process, regardless of what the outcome is in terms of enforcement, this is your opportunity, you're never going to have one like this again, to start to work with, and you have to find the right people inside the corporation to do this with, who understand how critical it is to develop a corporate compliance ethic that works from top to bottom. You need, wherever possible, and I'm now talking about pie in the sky. There are a few places that are really great, but they're very, very rare. At virtually every managerial level, in virtually every aspect of the corporation's activities that impacts regulation, and particularly environmental regulation and public health regulation, you need to have managers who have internalized this ethic of the importance of environmental protection and the importance of public health as a business obligation. This is what is called it's an aspect of what's called corporate social responsibility in the United States. This should be the goal of corporate hiring. This should be the goal of every corporate counsel, environmental counsel, or public health counsel, who has to deal with the imperative within the business of developing the environmental management systems, maintaining them, tweaking them. It's not something that you set up, press the on switch, and walk away from. This is something that requires constant care and attention, constant tweaking, constant interaction within and among the employees of the business. If you have consultants, working with them as well. I won't belabor the point anymore. I want to quickly mention an area of enforcement that I don't think is existing in Canada, or exists in Canada. You'll correct me if I'm wrong. We call them citizen suits in the United States. The formal legal term for it is a private attorney general. Most of the environmental statutes in the U.S., Clean Air Act, Clean Water Act, the Resource Conservation and Recovery Act, which is the solid waste, hazardous waste management law, have in their enforcement articles a citizen suit provision. And just to give you a flavor for what this, how this reads, this authority reads, it says any citizen, this is from the Clean Water Act I'm reading now, any citizen may commence a civil action on his or her own behalf against any person, including the United States, and any other government instrumentality or agency alleged to be in violation of an effluent standard or limitation, or an order issued by the administrator or a state with respect to a standard or limitation. The citizen may also bring a lawsuit against the administrator of the agency where there is alleged to be a failure of the administrator to perform any non-discretionary action. And there was a reference yesterday to lawsuits against, I believe, the EPA to force it to promulgate regulations, which the Congress had required in its authorizing mandate. This is an example of what a citizen can do in a citizen suit. The restriction is that, and there's a constitutional restriction, which I'll mention in a moment. The primary procedural restriction is that you have to provide notice before you file if you're a citizen seeking to enforce on your own behalf, have to provide written notice to the agency, the violator, and the state equivalent in which you're located, that you have identified the following violations by the following violator, and that you intend to bring a citizen suit action within 60 days, unless, and this is the way the statute reads, unless within that 60-day period, the environmental enforcement agency with jurisdiction over this particular violation, the law says, commences and diligently is prosecuting an action to deal with the problem that you want to bring your citizen suit for. If that happens, you no longer have the authority to bring your citizen suit, although you can intervene as of right, as an individual, in that lawsuit that the prosecutorial agency is, or the enforcement agency is commenced and is diligently prosecuting. The incentive, and I'll get to the constitutional limitation next, the incentive to do this on the part of a citizen or a citizen's group is that, and again, the statutes that authorize this have these provisions as well. When the court issues any final order under this section regarding citizen suit enforcement, it may, and I'm quoting now, award costs of litigation, including reasonable attorney and expert witness fees, to any prevailing or substantially prevailing party. You've got to fund the litigation, obviously, on your own. You've got to put the costs up front. But the incentive is, and you don't do this casually, of course, you have experts, you've ballparked what your chances are, you have an idea that you can make the violation out and that you will prevail or partially prevail. And if you do this, then you will get those costs reimbursed. And there may also be the opportunity for you to recover a bounty as well. The constitutional limitations, very briefly, are that in the last 10 to 15 years of the much, much more conservative U.S. Supreme Court under Chief Justice John Roberts, in a couple of cases where the late Justice Scalia issued opinions, the requirement of citizen suits, that a citizen is defined in the statute as any person having an interest which is or may be adversely affected. That definition of interest that is affected has been narrowed dramatically by the U.S. Supreme Court in recent decisions, but not recent, but in several particular decisions, in an effort, clearly an effort by the court to eliminate as much as possible environmental nonprofit enforcement groups, Environmental Defense Fund, Sierra Club, Greenpeace, etc., Natural Resources Defense Council. You have got to be able to prove that there are members of your organization who have an interest, not necessarily financial, but a real life interest in enjoying, protecting, avoiding the particular harm that you are saying is caused by the action of this particular violator. In an effort to preserve a wilderness area, for instance, from logging, illegal logging or something like that. You have to be able to show that some of your members actually use and enjoy going to that area. It can't be a theoretical interest. One of the things that the presence of citizen suit provisions does to a regulated business is it makes you realize you have another shoulder to look over beside the one you thought you would have to look over. When you know that there are roving bands of concerned citizens ever zealous to monitor your compliance with environmental laws and regulations, particularly if there is a citizens group located in the neighborhood around which you're operating. In the U.S., at least, that is a red flag of reflective proportions, just enormous proportions. You cannot forget about these people. You have got to be conscious of who lives around where you work, because, at least in the U.S., and certainly in California, New York, Illinois, New Jersey, places with very active environmental enforcement histories, Neighborhood groups. There's also a whole area of environmental justice that I can't get into today, but that is a major source of empowerment to low-income and minority and Native American groups in the United States who understand that they are getting the short end of every stick that is put in the ground by any public agency or by any business. Hazardous waste sites disproportionately sited in neighborhoods that are low-income and minority. So there are people who themselves will get and can fund or fronted the money to put up air monitoring devices at their home property boundaries to pick up whatever is leaving your facility grounds. They'll have their water tested. They'll compare it to the public records of your water discharge results and see where they can make correlations. So you're not just dealing with regulators in the U.S., you're also dealing with neighbors, and you're dealing with I think it's great, Robin Hoods. They're not stealing from the rich to give to the poor, but they're doing it in a different way. But there's a whole regime of overseers, public and private, that you need to be conscious of, and you need to develop good relationships with your neighbors as well. Time? Okay. May have a chance to say a few more things in the afternoon wrap-up session. I'll just close with a joke about the Superfund law, which in 1986 was reauthorized primarily to deal with innocent landowners who were and banks who were lending collateral and had a very, very tiny index of possessory ownership of the real estate collateral during a part of the loan, who were terrified that an EPA run amok was going to charge them with joint and several liability for the cost of cleaning up a property they had nothing to do with in terms of polluting. The reauthorization of Superfund in 1986 was called the Superfund Amendments and Reauthorization Act, popularly known as SARA. And I was dealing with an assistant U.S. attorney in the Land and Natural Resources Division at a panel shortly after this, and he said, we actually think it's more appropriate to use an Old Testament name to describe the Reauthorization Act. It really should be called Rachel, which is Reauthorization Act, clarifying how everyone's liable. Thank you.
We may have a few. Sure. We've got time for I think a couple. One from the web. Okay. What is the environmental bounty regime, and how does it work? I think somebody has an interest in making some money.
Certainly. It's not a provision which, first of all, it's an exclusively statutory provision. If it doesn't exist explicitly spelled out in a particular law, it cannot be read into one. You can't make it a private arrangement. It's not common law. It's only statutory. When it exists, and I'm almost certain, I know it's in the Clean Air Act and in the Clean Water Act. And at last I looked, it was a $10,000 maximum award that might be given to any person who provides information regarding a violation of the statute or regulations, which has a potential for substantial endangerment of public health or the environment. So you can't get a $10,000 bounty for pointing out that someone failed to provide a required record to an agency within 5 days of its due date. It's got to be a serious violation that you're bringing to the attention of regulators. It has to result in the investigation and a resolution adverse to the violator whose attention you brought the regulatory agency to. And if the agency determines, or the prosecutor determines that your information materially contributed to the successful investigation and prosecution of this violation, then you may be awarded the bounty.
Another question, which is sort of along the same lines. Can you speak briefly about natural resources damages claims and how they relate to citizen suit actions?
It's a good question. Unfortunately, I'm not going to be able to give a definitive answer to that. I know that natural resource damage claims they're relatively rare. And it's probably one of the more esoteric areas of environmental law in the United States, and typically requires the use of a particular kind of expert. I've worked with a couple of them before, although not actually in a resources damage claim action, natural resource economists who have very elaborate but also very compelling ways to put valuation on a wilderness area or certain kinds of, or a watershed. When, for instance, and I think this is going on, I believe this is going on in New York right now. General Electric Corporation was issued a final order upheld after a legal challenge by GE, brought by the US EPA, I think also the state of New York, to clean up over 9 miles of the Hudson River that has been contaminated with PCB discharges from General Electric facilities on the Hudson. It requires them to dig up silt below the riverbed where the PCBs have gone down and essentially been buried. It's going to be a Herculean operation, and I believe there's a natural resource damage component of that lawsuit. Unfortunately, I can't be more specific than to say that where there is natural resource damage as a result of an environmental violation, then the agency itself or citizen enforcers, depending upon who it is, will initiate an investigation into the extent of environmental resource damage or potential environmental resource damage, natural resource damage, and then begin to quantify. There are regulations that EPA has promulgated, by the way. I'm unfortunately not familiar with them, but you can look that up, and if you can contact me, I can help you do that.
I have just one brief question, and it goes to this whole question of citizen enforcers. A lot of environmental groups in Canada envy the groups in the United States. They would suggest they have advantages in terms of a litigious culture, which you're more likely to be impolite, for example, especially to government people. But they would also point to some of the legislation. Although we have provisions in Canada, some would say they're toothless at times, but we do have things like environmental bills of rights. I think what environmental groups here would really point to, though, is the funding. And you've talked about environmental groups in the States launching some very significant litigation.
Right.
Is this now largely a phenomenon of large groups like the Natural Resource Defense Fund and groups like that? Or is there actually room for small groups to pursue litigation, groups without that kind of funding?
Right. That's a very good question. The answer is yes, there is room. But I think what I would do is distinguish between, as you noted, the national, and in fact internationally recognized groups, Natural Resources Defense Council, Earth Justice, formerly Greenpeace, Sierra Club, Environmental Defense, any number of others. It's a much more finite universe now than it was 25 or 30 years ago. There's another one that I would point out is probably not as well known maybe to people in Canada, but is increasingly powerful and effective in terms of species preservation and climate change, called the Center for Biological Diversity. Has a superb, just extraordinary group of scientists and lawyers working for it. But every one of those organizations sees and has the funds to make its scope of reach national. And so they are very deliberate and very careful in terms of what they go after because they have the resources to be very discriminating in a good way. There, however, is room for very small, in fact, this is going to sound disparaging, I don't mean it to be, one-trick ponies. If you're in a neighborhood, if you're in a community that is suffering a real problem as a result of industrial or commercial activity that for whatever reason is not getting regulatory attention and you believe is having measurable and negative effects on your health, on the quality of your environment in a limited way in your neighborhood, there are organizations that Citizens for a Better Environment is one of them. I think the name is slightly different now, but that focus on small communities and that make it a point of developing small community dynamics to go after very, very narrowly focused problems. Again, the way that, and there are states that have citizen suit provisions as well. California doesn't call it a citizen suit. California statute calls it the private attorney general enforcement option. Again, it's got to be in a statute. It's not a common law principle. But where it exists, then there is the opportunity even for these small situations and small groups to coalesce and become effective. Yeah.
I missed one person, so this is the last question.
Jonathan, thanks for the presentation. It's great to have you here from the U.S. And I just wanted you to talk quickly about the criminal versus civil. In the first case that you cited, you decided to go civil,
right,
and then criminal, because I think what you've heard here is we have a real concentration on using prosecutions for everything.
Right.
I mean, the perfect example of that, which I think is just a ridiculous tool, is we have these things called tickets. And these tickets will result maybe a $400 or $500 fine, but it's just another way of starting a prosecution. So for these very minor matters, if there's some sort of incident to the company, they can still basically say, we don't want to pay this ticket because it is a conviction, and you can have this long quasi-criminal trial. What you don't hear in this conference that much, because there's not that much use of, are civil tools. We don't sue polluters in courts like that. We don't use administrative penalties. And so we're stuck basically using these quasi-criminal trials for these things. And what I always find when I hear the U.S. prosecutors talk about these terrible incidents where you have this sort of, company covering things up for years and years, and you don't hear a lot of those cases up here in Canada. And I just always wonder whether or not we're so focused on using the courts for these matters that should be dealt with civilly, and we don't basically have the ability to take these resources for criminal stuff, which take a long investigation to uncover. So I just wanted to talk about the civil versus criminal.
No, you're right, and we did talk about this yesterday, Jamie, and I appreciate you bringing it up again. There is, I'm gratified to say, there's a very, very wide range of enforcement arrows in the quiver of enforcement agencies. Both regulatory and their prosecutorial, and when I say prosecutorial, I mean civil and criminal prosecution, prosecutorial agencies. What I call the early days of environmental enforcement in the U.S., the early to mid-1980s for us, when criminal laws were first being used to sanction environmental violations, as well as civil ones, there were no options. It was either a criminal prosecution, it was misdemeanor or felony, depending upon what the sentence was. If it was a county jail time in the state law, it was a misdemeanor, had to be less than a year. If it was more than a year in state prison, it was a felony. Similar kinds of distinctions in federal statutory law for criminal, but it was either a civil lawsuit or a criminal prosecution, nothing else. Over the years, as I believe, the environmental enforcement regulatory regime has been more deeply institutionalized in the United States, a much more nuanced range of enforcement options is now available. And for the reasons that you were referring to and others, it offers, and I forget who made this remark yesterday, it offers the option of seeing things as other than nails where you can only use a hammer, seeing problems for what they are evaluating them relative to other problems, and tailoring the choice of enforcement mechanisms that you use to fit that particular violation. All of the things that you read about in terms of evaluating a gravity-based offense, or making a determination about gravity-based offenses, or economic benefit analysis, you use as well in deciding whether to bring what amounts to a slap on the wrist in an enforcement inspection context, an administrative penalty action, short of a civil lawsuit, short of criminal prosecution. I'll make this as quick as I can, and I'm glad you brought it up because I discovered I'd forgotten about this. In the Clean Air Act, in addition to administrative, what are they called? Administrative assessment of civil penalties provisions, there is what's referred to as a field citation program, where the EPA, and it has implemented this in consultation with the Attorney General and the states, has established regulations to enforce minor violations of the Clean Air Act with civil penalties that may not exceed $5,000 per day of violation. There is a host, the usual range of due process hearings, opportunities, notice, opportunity to be heard, appellate remedies, even for this field citation program. My perception is that both lawyers, enforcement lawyers, prosecutors, and regulatory agencies, and certainly corporate counsel, are thrilled that there is this range of options that is now in place and able to be used by enforcers, so that they can argue, the violators can argue, okay, game's up. We're not talking about whether it happened. We're talking about how serious it was. We're talking about what our own history was. We have a great compliance record, or our compliance record isn't great, but it's not terrible. However you can spin it. So we ought not to be punished this way. We ought to be punished that way. And because this is all public record, you have access to a history of what the regulatory agency's enforcement has been with respect to a particular mechanism that they've used in the past. You can take this, compare your behavior to what's gone on in the past, how that was enforced, and say, we're more like them, not like these guys. Do that accordingly. And that's now possible to do to a much greater extent.
Thank you very much. And I think it's obvious everyone's interested in the American experience. And I'll let you know right now that Jonathan will be joining us for the final panel early this afternoon. So this is not your only chance to take a shot at questions. Final presentation is by someone you recognized from yesterday, Heather McCready. She's back, and is going to talk to us now about, again, sort of a cutting edge, at least in Canada, cutting edge approach to environmental enforcement, taking lessons from what's happened in criminal law enforcement. We can go 15 minutes over.
So we're just swapping presentations. What you see up there is what I did yesterday. So I'm going to do something a little bit different today. I'm going to talk to you about the use of intelligence in regulatory enforcement. There we go. And I'd actually like to thank the two presenters before me who provided really excellent context for what I'm about to talk about. Where's the go? All right, well, we're setting that up. I'll just give you a bit of background. So when I first started at Environment Canada about 6 years ago, I discovered after some time that we had an intelligence function in enforcement, and this surprised me. I didn't really understand how intelligence would be used in a regulatory context, and I don't think I actually really understood what intelligence was back then. So I discovered over time that we had an intelligence function in the branch, and what it's used for, it's akin to the way that you would see intelligence used in a policing context. So not a national security type of intelligence, but intelligence that's focused on the behavior of criminal actors. And in the environmental regulatory context, this would be more like a regulatory infraction context, but you can look at it in the same way as you would criminal behavior. So it's focused on the behavior of human beings who are doing the wrong thing. And this wrong thing can either be an actual crime in the way that you would see it in a policing context, or it can be seen as a regulatory infraction, which is more the context that I work in. So at Environment Canada, we've been making a concerted effort over the last few years to improve our intelligence program. And as part of that, I ran the project for about 1.5 years and learned a lot about intelligence and a lot about intelligence-led enforcement and policing, and was invited along with a colleague of mine to write an article that would become a chapter in a book on environmental law. So that's the paper that I've presented, which is available on the website. And what I've done with this presentation is to just summarize a few key points from that chapter. So what I'm going to talk about today is what is intelligence, how we've adopted the principles of intelligence-led policing and moved that into what we call intelligence-led enforcement. I'm going to talk about some challenges with the name, which have turned out to be a lot more important than I thought they would be at the beginning of my work on this. I'm going to talk about how this is different from the regular way we've been doing business over the years and the way that most agencies do business. And I'm going to make a little case for you of why we would want to use it in an environmental or regulatory context. And then I'm going to talk about how we're doing it. So we'll jump in whenever they get the presentation, but it's not that necessary. So a bit of background. As I mentioned, we've had an intelligence function at Environment Canada in the enforcement branch for probably about 15 years. One of the presenters yesterday referenced a parliamentary standing committee report from about 1998 that was looking at the environmental enforcement program. If you haven't read it, it's actually really excellent reading. And that was the precursor to the enforcement function at Environment Canada being split off into its own branch. That report also looks at a little bit the intelligence function within the department and had said, you've got some people doing intelligence. They're not really well staffed. They're not integrated into the rest of the program. You basically have a broken program here. What are you going to do to fix it? So that was identified as far back as 1998. It turns out that we're not alone in that. Over the course of the time that I ran the project, I learned that many agencies and governments have an intelligence function that is not well staffed, not well resourced, and not well integrated into the rest of what they do. So the good news was we weren't alone, but the question was how to fix it. There had been a number of attempts to fix intelligence in our program before. And I was aware of these from finding old PowerPoint presentations in filing cabinets, that the further I would go back in the filing cabinet, they would get more and more yellowed and bats would fly out. And I think the reason why these didn't succeed was every good idea needs the right time. You have to have other things happening around you that will facilitate that change happening. And the previous efforts had been bottom-up, intelligence staff trying to save themselves that didn't get a lot of management buy-in. So back in 2012, the department decided to put some effort into improving the intelligence program. That was initially led as an off-the-corner-of-your-desk initiative run by busy people, so that didn't really get anywhere, not surprisingly. And then in 2013, we decided that the project needed a full-time project manager and at least one other staff member to run it. So that's where I came involved in 2013 in running what we came to call the Intelligence Renewal Project. The project is still going on. I left it in the spring of this past year to take on a new job, but I'm still involved as a director of the project. And what we've done is dedicated 2 full-time staff to do absolutely nothing but work on improving our intelligence program, and it's a concerted effort across the agency. As I mentioned, every idea needs the right time. There's a lot happening in intelligence in Canada right now that I wanted to highlight for you if you're interested. There's an initiative out of the Privy Council office called Community 2020, which also has one dedicated staff member running it, which is better than nothing. And it's an initiative to bring together Canada's various different intelligence functions. There's the core 4, which is CSIS, CSEC, Privy Council Office, and D&D that do the national securities intelligence for Canada. But then there's everybody else. including Environment Canada. So Community 2020 is looking at knitting us all together and seeing how we can help each other. So what is intelligence? This is not something I understood when I started on the project a few years ago. People use this term wrong all the time. Usually when people say intelligence, they're actually referring to information, and that's not intelligence. Intelligence is information, raw data, things from all sorts of sources, informants, tips, surveillance, that's been put through a process to become something more. So it's been analyzed, it's been verified, it's been turned into something that supports a decision and is made for a specific purpose. So it's a process for interpreting raw data. It's also a methodology for analysis, a defined, consistent methodology and different ways of looking at an issue and analyzing it. And finally, it's a product that informs decisions. And this has been my most important takeaway from intelligence. One of the most difficult things that a lot of intelligence agencies find is the people working in intelligence tend to hoard that information to themselves and don't want to share it with people for all sorts of reasons. There is absolutely no value in a brilliant intelligence product that sits in someone's desk because they're afraid to share it. It has to inform decision making, otherwise no action can be taken. So it has to get to decision makers at the right time and in the right format for them to use it. So a 40-page intelligence brief is completely useless to me. I am way too busy to read 40 pages and make a decision on any given day. So it's got to be tailored specifically to the client, using words and in a format that client can use and act on. So what type of decisions? We speak of 3 different types of intelligence typically. Tactical intelligence is something that we used to be, I think, the best at Environment Canada, and most agencies will start here. Tactical intelligence is something that usually informs an ongoing investigation. So it's about a specific thing, a specific event or person. Maybe it is a link chart that links a couple of people together in a small organization. Operational intelligence is a little bit broader than that. So it could be about looking at a network of crime in a particular area and how best to interdict or intervene in that particular scenario. Strategic intelligence is something that a lot of agencies struggle with, and this is where we're putting a lot of our emphasis. This is where you use intelligence to look strategically at the problem areas that you're encountering and help the organization figure out where to direct its resources. So this is where we would use intelligence to inform our planned inspections. So what are we going to focus on this year and why? And what are the best ways of intervening in the situation that we're seeing nationally in Canada or potentially internationally? So we bring in intelligence-led policing. So the godfather of intelligence-led policing is someone named Jerry Radcliffe, who is in Philadelphia. He's a former cop from the UK who is now an academic in the US. Intelligence-led policing is based on a model from the UK that he writes a lot about. It's a business model that takes intelligence and integrates it into the entire planning process of a police agency. And I'm going to talk to you about how. Hang on. What we've done with it is we've taken intelligence-led policing and turned it into what we call intelligence-led enforcement, which is the expression that we use to describe taking the principles from policing and bringing them into the broader enforcement context, which is what we're trying to do. As I mentioned, there's some challenges with the name. So when I first started on this project back in 2013, Karina Barker, my co-author and colleague on the project, we spent a lot of time having existential conversations about what to call this. Because the problem with intelligence-led enforcement is it makes officers feel like Intel staff are now their bosses, and they don't like that. And that's not actually what the concept is. The concept is meant to mean instead of having intelligence support an ongoing investigation, intelligence leads the agency by putting it up front and helping management make decisions about where we need to go in the first place. It's not meant that intelligence staff drag operational staff around by the hand and tell them exactly what to do every day. So we debated a lot what to call it and decided to use that term for the article that we wrote because it's the accepted term in the industry and people would know what we meant. But the department's actually now using the expression intelligence-driven enforcement, which seems to be more popular amongst our officers. And if they want me to call it cupcake, I'll call it cupcake just to get it done, whatever works. So we're going with intelligence-driven enforcement. So how is it different? So this is another quote from Jerry Ratcliffe, and I wanted to highlight the fact that I've mentioned this a couple of times, but it's key to this. It's taking intelligence which would have been used to inform or support an ongoing investigation, and instead of just using it for that, bringing it through your entire planning process. So why did we even inspect that company in the first place that led to the investigation that intelligence is now supporting? We want to use intelligence to identify the places we should be proactively going. And not only that, but when we get there, what's the best method of intervening in that situation? So what are the modi operandi of the people that we're looking at? And that's what makes this different than other ways of using regulatory enforcement. So we all talk about risk-based planning. Everybody does risk-based planning, right? But not really. We're all really, really, really busy. And we do our best to take a step back and analyze the situation and use government resources properly. But we're all way too busy to do this really well all the time. And I think we can probably all admit that if we're being honest with ourselves. What I find that intelligence adds to the equation for our organization is it provides an established methodology to look at the problems that we're encountering and ways of dealing with that. So it's been an important framework for us to really do risk-based planning. So here's what it can do for us. It can identify emerging trends and patterns, as I mentioned, so that we can actually target our actions to have a greater impact. It can provide early warnings. So I mentioned yesterday that we do tend to do a lot of reactive enforcement. One of the later presenters interpreted that to mean that we're dealing with public complaints and going where people tell us to go. It's not exactly that. It's Mount Poly happens and we're going to go. Lac Mégantic happens, we're obviously going to go. We don't know that those things are going to happen. What we're hoping intelligence can do for us is give us some indicators of where we're likely to see problems. And Jennifer actually provided a great example. Financial stress in a natural resources and extraction company is a really good indicator that there might be some environmental problems. So you can pinpoint those sorts of things and think about devoting resources to that sector at that time. Of course, we'll still use it to support investigations, but we're more hoping that it will support our strategic analysis and help us figure out specifically where we need to go in the future. And as I mentioned, it informs decisions, which is something I used to keep on my wall when I was working on the project, and try to inculcate that value and understanding in all the intelligence staff that we work with. So here's how I explain how intelligence works. So we're gonna play a game of whack-a-mole for a couple of minutes if I have some time. So you may all be familiar with the arcade game whack-a-mole. You've got these little moles that pop up, and the goal is to hit the moles, and the more you hit, the more points you get. I often feel in my job that I play whack-a-mole. So the moles are the environmental harms. They are the behavior of the wrongdoers who are breaking our regulations. They pop up, and we just whack the crap out of those moles as fast as we can. And we try and get faster and faster and faster and faster. What intelligence lets us do is to step back from the whack-a-mole machine for a moment and ask a few key questions about what exactly it is we're doing. First question, why are we whacking moles? Is the whack mallet the best way to intercept a mole? Maybe we should poison them. Maybe that's a way to more effectively kill these moles. Nothing against moles personally. But are we using the best method to intervene in this situation, or is there some other method based on studying mole behavior that can give us more bang for our buck? Another question we could ask, why are we whacking only one mole at a time? Maybe we can whack groups of moles. Maybe we can stop them from popping up in the first place if we can find a better way to intervene. Another question to ask is, why are we whacking moles? We're spending all this time whacking these moles, and over here, there's a toxic waste dump leaking things in the water. Is this the right place to be focusing at all? Is a really good question to ask. And I find that when things are popping up on a daily basis, you don't even have time to ask if you should be reacting to them. Maybe you should be doing something else entirely. Another question we could ask is, why are we whacking moles? Is this actually Environment Canada's problem? Or would somebody else be a better placed agency to be looking at this situation? What's the core of the actual problem here, and who is best placed to solve it? So how are we doing it? When I took on the leadership of the Intelligence Renewal Project back in 2013, I didn't honestly really understand what intelligence was or how we were going to use it in the agency. I took on the project for a couple of reasons. The first was curiosity about really what Intel was and how we could use it. But mostly I was looking to experience leading an organizational change project. As I've said to a couple of you over coffee yesterday, when I first came to Ottawa 6 years ago, I thought that I was going to be much more interested in policy, because policy just sounds really cool. Let's do the big thinking and make the big decisions, and that's what I wanted to do. But I realized very quickly that there are a lot of people in this town who are really good at that stuff. We have a lot of fantastic thinkers here. What I think we need more of are doers. Implementers, people who can take those big ideas and actually make them happen in real life. So I was interested in how do you do that? It didn't even matter at the beginning that it was intelligence. I wanted to see how do you change an organization. Since then, I feel like the Remington guy in those commercials from years ago that I loved it so much I bought the company. I have absolutely drunk the Kool-Aid and think this is the way to go. So what we did with this project is to figure out where the pressure points were in the program and what we needed to improve to have a really good intelligence program. Since that time, I occasionally find myself around a table with people from the Core 4. So I'm with D&D and CSIS and CSEC having a conversation about Intel, and they're not quite sure why I'm there because I'm from Environment Canada. And I used to not be quite sure why I was there either. And now I say, here's what I'm good at. You're all good at national security's intel. Lots of people in this country are good at doing intelligence. One of the things that I can now say Environment Canada is good at is we're, the collection of people who work on this project are some of the few people in Canada who actually know what does it take to build an intelligence program? What does it take to fix it, to run it, to make it work really well? And that's something that we are sharing now with other partners in the Government of Canada. So we broke it up into 5 streams of work. The first is alignment. In the article, I refer to this as what's called tasking and coordinating. That's the intelligence lingo for that. What it basically means is the process of how intelligence staff get tasked with their work, do their work, and disseminate it back to decision makers. For us, we realized that the problem we were having with intelligence wasn't the intelligence program necessarily. Yes, they need more staff, they need a computer system, they need more training. But even when we get intelligence to throw the perfect pass to the end zone, the problem we had is that the enforcement officers on the other end didn't know how to catch that ball. So a big focus for me was looking at the organization as a whole and training operations staff and enforcement officers on intelligence, their role in intelligence, how to use it, how to task better. And we came up with a procedure to align the operations group with the intelligence group. So it's how that information flows around inside the bureaucracy, which tends to be quite important in any organization. The next one is the craft of Intel. Intel people call this tradecraft. I just call this craft. It's what you do on your job. We realized that we had, across the country, people doing the same sort of product but with different names, and people doing something with different name. So it was actually the same product or vice versa. Basically, there was no standardization. And so clients of Intel didn't know what to request of intelligence staff. And the managers of Intel didn't know how to evaluate that because there were no standards. So we've standardized the craft of intelligence within Environment Canada and have tried to make it up to the best practices of the rest of the Government of Canada, which allows us to trade products with other departments and communicate better together. People. So, any intelligence organization needs intelligence staff. They need to be trained, they need to be hired with the right kind of profile and have the right kind of mindset for the work that they're doing. We see 3 types of intelligence staff. There's an intelligence officer, who's somebody going out in the world collecting intelligence. Intelligence analysts, who are analyzing that information and turning it into intelligence products. And then the managers who manage that function. And they all have a different role and a different skill set, and we need to support the development of all of those people. Technology. There is a lot of data out there in the world. You hear people talk about data mining all the time. I had made a comment recently at work that I feel like in Environment Canada we're data drunk. Even within our own organization, we have so much data, not to mention all the other things out there, for example, HS codes that we can get from CBSA and things like that. So it is not a good use of resources to have human beings the only entity going over this data and manipulating it. So any intelligence program requires a very sophisticated IMIT system to take in, manage, collate, analyze all of this data, which is something we're working on. Another thing that any intelligence program needs is governance. And this is something that any government program needs or any private program needs. And by this I mean the bedrock underneath the program. So it's things like who reports to whom on a basic level, but it's also formal MOUs with other agencies that allow you to share information. One big thing we're working on right now is performance measurement. How do you measure the performance of intelligence? We're making efforts to come up with good performance measures now before Treasury Board asks us to. A lot of organizations wait until they're forced, and then they wind up counting numbers of reports, which is not meaningful to anybody. So we're trying to find ways to measure the value of intelligence and to make sure that our intelligence program is providing the right information to the rest of the branch in the department. Finally, you need some vision. Any organizational change project needs vision and leadership from the top, and it needs dedicated staff to make it work. Organizational change is not a hobby that you can thrust upon your busy people to do with everything else they're doing. If you actually want to do something like this, you have to really do it. You have to sink the resources and time in it to make it possible. And before I conclude, I was really struck by both of your presentations because, as I said, they did give some excellent context for what we're talking about. When I'm selling intelligence to the rest of Environment Canada or to the rest of government and trying to explain exactly why we use it, some of the hesitancy is, it's a lot about what Jonathan mentioned towards the end of your presentation when you were saying people don't understand why we would treat environmental violators as criminals. So why would we apply criminal intelligence techniques to regulated parties? They're not criminals, are they? So I have two answers to that. And the first is sometimes they are. And I think you actually provided some great examples of what I would call legitimate criminal behavior, in which case we don't even have to do much with the intelligence techniques to have them apply in our context. We are looking at legitimate criminals. And we stumble across them all the time. We've stumbled into some of our regulatory infractions. The people breaking the law turn out to be part of biker gangs. So they are involved in lots of other really bad stuff too. There are smugglers and poachers that look like more classic criminals. And secondly, even in the context, so what Jennifer was talking about, where you probably do have virtuous clients who don't want to pollute, what we're focused on is the behavior, the wrong behavior that we're trying to correct. And the same types of analysis that is used in criminal intelligence analysis can be applied to that. So you're looking at the behavior you're trying to correct, trying to spot trends of it, trying to spot indicators that will direct the regulatory agency to spend more time there. And it doesn't have to be what you would consider full-on criminal behavior to use that type of analysis. So the example I used earlier, financial stress in the mining industry is a great indicator that there may be environmental infractions on the rise. That's one example. Those are the sorts of things that we're looking to use intelligence for to direct the resources of the work that we're doing. So I'll wrap it up then so I don't keep you from break for too much longer, unless there are any questions.
Thanks so much. That was not only interesting, but remarkably cogent. So, lawyers aren't always noted for being cogent. We do have time for a couple of questions because we can expend the break. Yes, Paul.
Sorry, Heather, I'm constantly going to ask you questions. This sounds like a great approach. I know nothing about it, and I've never heard it spoken about at the MOECC level when coming to doing things like planning inspections.
You have intelligence at MOECC.
We have an intelligence-led thing. So it sounds very resource-intensive, though. And do you find that it expends a lot of resources? And how will it change when you're looking at, let's say, a risk-based approach for inspection, saying we're going to go to the facilities that discharge toxic substances that actually basically change the matrix going, you know what, no, we're actually going to focus on this.
It is resource intensive, and I think the hard choice that organizations have to make is every time you put $1 towards something that isn't an officer in the field, you get questions. rightfully so. That is the focus of the work that we do, is making sure that we have sufficient officers to do the work that we do. But the value proposition here is that if we have better analysis and better targeting, we're going to put our resources in the right place. So we're going to do more with the same, or hopefully not fewer officers. But it is an issue, and we're not fully staffed right now by any means in intelligence in our branch. It's something we're going to have to do slowly over time. And it does sound like a great idea, but we haven't gotten full buy-in yet from everybody, obviously. If you ask certain people in Environment Canada, they'll say, this is fantastic. And then there are other people you could ask whose names I won't give you. It's a work in progress, because you have to get that buy-in from everyone, and particularly from people who are not in intelligence. I've got a vacancy, I want to staff it. I can't, because you're going to hire more of those people. Unless they buy into what it's for, they're not going to support that decision.
Hi, I was wondering if you have gotten any answers to the mole question, the how, the what, the who, any preliminary. I think that they're very, very good questions to ask, and I'm wondering if there's going to be a change of direction. Or
I think we're starting to. I mean, like I said, it's a work in progress. We regulate so many different sectors that it is difficult to figure out where we need to be, because it's all of Canada. Particularly if you look at the Fisheries Act, it's everybody. So I think we're starting to get a lot better at that. And what we need is the cooperation and support of the rest of the department, because they sit on so much good information we could be using. Fortunately, we're getting a lot of uptake from the rest of the department now. We did a presentation at our high senior management committee last fall that went way better than I thought it would, because the whole rest of Environment Canada is very science and regulatory focused. Enforcement is a very niche thing, so we're often trying to explain what that's about, and I thought it would be quite challenging to explain what intelligence was then, because it's further into the Russian doll set. But people have gotten really excited about it, so much so that I now feel like we need to dial it back. And I had made the point in the room, I think we had 25 people in the room for that meeting. I said, we have fewer people working at Intel than there are in this room. So I feel like I've created a situation where we have a high Zagat-rated hot new restaurant that's got one cook, and we can't handle now the demand coming to us. So it's going to be a work in progress, but I think we are starting to get those answers. It's a very long way of answering your question.
Okay, thanks very much. Thank you, Heather, and thank you to the panel. This has just been a fascinating start to the morning, from oily ducks at Syncrude to whack-a-mole. I can't imagine what's ahead.